The Oakland verdict is barely a week old, and now a federal magistrate has ordered OpenAI to turn over its Musk trial depositions, Altman, Brockman, Nadella, to the copyright plaintiffs.
You're listening to Musk v. Altman Daily. I'm Devin, Cassidy's here, and today the trial record stops being a trophy case and starts getting used in a totally different federal fight.
We've got the Bloomberg law ruling, Brockman breaking his post-trial silence on the 72-hour Altman ouster, and a Colorado outlet that may have summed up this whole week most honestly. And yeah, we'll tell you who gets the credit. Here's Bloomberg law.
OpenAI Inc. must produce testimony from the company's recent trial victory over Elon Musk and xAI as part of separate, sprawling copyright litigation against the artificial intelligence giant, a federal magistrate judge ruled.
Picking up from Friday's governance thread, that Musk trial record isn't just sitting in a filing cabinet somewhere. Magistrate Judge Ona Wang in the Southern District of New York ruled Thursday that OpenAI has to hand over depositions from Altman, Brockman, Nadella, and OpenAI's entity designee to the plaintiffs in the copyright consolidation. The theory is simple. Those depositions may show whether OpenAI's use of copyrighted training data is as commercial as the plaintiffs say it is. And that matters because commercial use is factor one in the fair use analysis, and OpenAI has been trying to soften exactly that point. There are 19 copyright suits consolidated for pretrial in New York, and now the Oakland testimony is getting routed straight into that fight.
So the depositions where Altman and Brockman talked about the long road to for-profit are now going to the copyright plaintiffs, the same people arguing OpenAI is a commercial operation exploiting their work. That's not a neat separation. That's the wall between the two cases getting kicked in.
Judge Wang also said producing them wasn't burdensome, especially after the plaintiffs narrowed the request. So OpenAI didn't even get the "this is too much" argument to land. Bloomberg Law had that first, and the order came down Thursday.
And Brockman just did the Knowledge Project interview about the 72-hour Altman ouster, publicly narrating the governance chaos, while he's also under a court order to hand that same deposition to the copyright plaintiffs. That is a weird place to be.
GJSentinel with Matt O'Brien.
The soaring costs factored into the trajectory of OpenAI, which began in 2015 as a non-profit dedicated to developing AI for the common good, and is now a capitalistic enterprise valued at $852 billion. As San Francisco-based OpenAI and other AI companies move toward historically large Wall Street debuts, the trial also raised questions about whether anything but commercial interests can steer AI's future.
Credit where it's due. This framing comes from GJSentinel, a Colorado local outlet, not a national desk. And their headline is doing real work here. 3 weeks in federal court, and what we got was clues. Not a ruling on whether anything but profit can steer AI's future.
A nonprofit valued at $852 billion. That sentence should make everybody stop. And Musk's 2018 email. This needs billions per year immediately or forget it. That wasn't a villain speech. That was the constraint both sides knew about privately while arguing mission in public.
Which is why the trial's silence on the merits matters more than the verdict itself. The jury never reached whether the conversion was lawful. And now those same depositions from Altman, Brockman, and Nadella are being compelled into the copyright case, with inconsistency as the exact theory.
So the Oakland courtroom produced clues, and a federal magistrate judge is now sending those clues into a different case. The trial didn't close the door on exposure, it spread it around. That's the honest read on where the week landed.
From Lucia Stein and Tavleen Singh at ABC News.
After Sam Altman and OpenAI's recent victory in a drawn-out legal battle with billionaire Elon Musk, the bitter rivalry between the former friends is now set to move from the courtroom to Wall Street.
ABC News, Lucia Stein and Tavleen Singh, is framing the post-verdict moment as a shift from Oakland to Wall Street, specifically the IPO runway. And that matches what Bloomberg Law handed us this week. The same Altman and Brockman depositions that didn't end in a jury verdict are now being compelled into the copyright litigation. The rivalry didn't end. It just picked up a couple of new venues.
Musk calls him Scam Altman on social media, while Altman tells Bloomberg TV he feels for him. That's not really a rivalry anymore. That's a one-sided therapy session. And meanwhile, a magistrate judge is routing both of their sworn testimony into a totally separate federal case.
The Wall Street framing is real, but here's the wrinkle. The IPO disclosure picture just got messier. It's not only what the S1 says about governance, it's that the depositions behind those governance questions are now moving through copyright court, specifically to test for inconsistency. That's a live legal mechanism sitting inside the IPO timeline.
Musk is quoting Lord of the Rings about the Ring of Power corrupting Altman. But Brockman just gave The Knowledge Project a public interview about the 72-hour boardroom meltdown, while his deposition is also under subpoena. I don't know which of these guys has less control of his own narrative right now.
LavX News writes,
In a recent Knowledge Project interview, OpenAI co-founder Greg Brockman recounts the boardroom showdown that led to Sam Altman's brief ouster, the rapid formation of a backup entity, and the technical and governance decisions that have shaped OpenAI's trajectory.
LavX News is out with details from Greg Brockman's Knowledge Project interview, and the timing is not subtle. He's publicly walking through the 72-hour Altman ouster, the overnight Phoenix backup entity built at Altman's house, the board vote counts, all of it, while a federal magistrate judge has just ordered his deposition handed over to copyright plaintiffs to test for inconsistency.
A backup company built overnight at Altman's house. I need everybody to sit with that for a second. That is not a governance structure. That's a heist movie. And now that story is sitting right next to a subpoena.
The detail that matters legally is Brockman's explanation that they walked away from the pure nonprofit structure because the board couldn't fund GPT-5 scale compute. That's his public rationale for the conversion, and the copyright court is pulling his sworn version of that exact rationale. Whatever gap exists between those two accounts is now a live federal issue, not a podcast aside.
So Brockman's out here doing press about the governance meltdown, while his deposition is being routed into a different case. That's not a coincidence. That's two timelines running into each other. What does inconsistency even look like here, Cassidy? What's the thing a copyright plaintiff's lawyer actually circles in red?
Potentially anything where his public explanation for the structural change doesn't line up with what he said under oath about the founding intent. If he told the Musk trial the nonprofit mission was the load-bearing wall, and now he's telling a podcast it was dropped because of a compute cost spreadsheet problem, that's your inconsistency. That's what the magistrate's order is meant to expose. If you follow Musk v. Altman, you'll probably want the infrastructure story too. Check out the Data Center Daily, a daily briefing on AI compute, hyperscaler CapEx, the power grid, semiconductor supply, and energy markets reshaped by intelligence at scale. Find it wherever you listen to podcasts. You'll find links to everything we covered today in the show notes. If a story caught your attention, that's the place to dig a little deeper. That's Musk the Altman Daily for this Monday, May 25th. This is a Lantern podcast.